Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People versus McDonald. Submitted. Askins v. Santos. Yes, Mr. Askins? Is the respondent here? In such cases, Mr. Askins, sometimes we ask the parties if they wish to submit, meaning not talk to us. But if you'd like an opportunity to talk to us, I'll give you 3 minutes, just to highlight what's in your brief. Okay? Bianca v. Bobby H. is submitted. Gulati versus Gulati. Five and 2 and 5. People v. Luz Hernandez. Three minutes. People v. Michael Ortiz. Submitted. Scanlon v. South Street Seaport. Okay. We'll go with 5 and 2 and 5 and 2 and 4. Reeves v. Foundation for the Child Victims. 5 and 2 and 5. W. Jeremiah. Submitted. People v. Mustafa Bari. Submitted. Tender Touch v. Tunuzeg. Five and 2 and 5. Stanogo v. Giacomini. 3 and 1 and 3. 415 East 12th Street versus Duran. 3 minutes. People versus Michael Cortez. Submitted. Anthem Healthcare v. Campion. Yes. Okay, Aetna and you get 2 minutes. The city will get 5 minutes, and appellant will get 6 and 2. I'll give the city 6 minutes, actually. Six minutes for the city. Thank you. Brennell Realty versus Planetarium Travels. You have a cross appeal, do you not? Yes. Would you like time on rebuttal? 1 minute. 5 and 2 and 5 and 1. Goldman v. Icaro Media. You don't have a cross appeal, though, do you? Okay, 4 and 2 and 4. People v. Steve Darbasi. 5 and 2 and 5. People v. Eduardo Rosario, which are the next two appeals, are submitted. And Sekosin v. Bronx Women's Medical Pavilion is submitted. First case up is you, Mr. Askins.
Can you hear me?
You can get it a little closer. Okay.
Thank you, justices, for hearing my case. My name is Delroy Askin. I'm a pro se litigant. I had a court date on June, if I'm correct.
Mr. Askins, would you take the microphone and pull it a little closer to you, and perhaps you could speak louder? It's very hard to hear you. Okay?
So I'm a pro se litigant. On July the 19th, I believe, I had a court appearance, or June the 19th, sorry, I'm not looking at my documents. And I didn't make that hearing. So I was served, but I never knew that I had I was served, but I never knew that I had an actual case. So I had a procedure done in the hospital on June 18th. And the reason why I'm mentioning the June 18th date is because had I known that I had a case on the 19th, I would have informed the courts. So they postponed it to the, the 29th of July. So on the 23rd of July, 2024, I end up in the emergency for my right leg, and I was after leaving the emergency room, I was there all morning to the late evening, and once the plan was for me to not get up, just stay home for the next 5-6 days, and that's what I did. I never knew I had a second court appearance date. Had I known both of those dates, I would have gotten in contact with the court to let them know. So the case ended up getting dismissed because I didn't show up. So the point I wanted to make was that when I was served for the first date, the June 19th date, June 19th date, I was served for that. But when they sent the second date, nobody called me, nobody informed me that I had that date. Had the adversary had let me know about that date, then I would have knew I had a court date. So that's why I'm hoping and believing that you guys will understand. I have medical records, documents, and everything that show that it was a medical situation, and I didn't know about that date. No, anytime you're in a court proceedings, and when one side doesn't show up, they always tell the other side, make sure you let the adversary know that he or she has a court date. And that's where I'm at now. I did try to reach out to Ms. Adams' court clerk attorney and to get the transcript and everything so I can continue to support my case. I have all of these documents. When she did respond, she said she wasn't there that day. And then the next email that she sent me, she said that
Mr. Askins,
they didn't do anything on the record.
the red light is on, so the time is up. I don't know what's going to happen in this appeal. but it's possible that you may need to move in the court below, in the trial court. So wait till we issue our decision, and that may give you some direction about what you do next. Thank you very much.
Thank you, thank you.
Next case up is Gulati versus Gulati. Please.
May I proceed, Your Honor?
Please.
Good afternoon, John Farley, Rottenstrike, Farley, Bronstein, Fisher, Potter, Hodas, LLP, on behalf of Defendant Appellant Nobel Gulati. There are several issues before the court. The gating issue, I think, that is readily resolved and should be is the fact that my client was never served properly with the divorce action and summons in this case. The wife proceeded by use
No, we understand the sequence of service, but you, one of the places that she alleges that she attempted service was at a business with which you say he was, quote-unquote, associated. In
Yes.
fact, he's the CEO of that company, is he not?
My understanding, Your Honor, is that my client is the CEO of an associated entity, but
What does
maybe
it say on the website about his association?
I have to say, Your Honor, I don't know, but let me cut to the chase, if I may.
Please.
We do not challenge anywhere in our papers that it would have been possible for the wife to attempt to effectuate service of him at that address. She says in her ex parte papers and in her verified complaint, bindingly, that that is where he does business, and that's his office in Manhattan. She attested that she had ready access to it via her process servers who were permitted to enter the business and attempt to serve her husband. She further attested that her husband possessed no home in Florida, but only in Manhattan. She attested that she and her husband lived together in the same home in New York County. So if we accept, as we must, for purposes of this argument anyway, the wife's sworn testimony that her husband is not, as we see in the other cases, behind a walled compound in Saudi Arabia. He hasn't fled to Iran. She hasn't had to hire private detectives to find him, and they couldn't. Her testimony is she and he live in the same apartment in New York County, 1 mile from this courthouse. Her testimony is that his place of business is 1 mile from this courthouse in New York County. Her testimony is that she and her process servers had unfettered access to both locations, and she attests that she attempted to serve him for a total of 36 hours before resorting to subpart 5.
Alternate service was obtained invalidly?
Yes,
Okay.
yes. And I think the issue is that the court below, among other things, did not reach the invalidity of that service, but instead denied our motion.
No, I tend to agree with you about that you didn't need to make a 2221 motion,
No.
that you could have argued in front of the court. However, the record before us is sufficient, I think, for us to make a decision. Wouldn't you say? I mean, one way or the other.
So are you asking, Your Honor, whether I believe that the record below is sufficient for this court to determine whether subpart 5 was satisfied? I would say yes.
Okay,
Yes. To continue, if I may,
please.
in order to make use of subpart 5 of CPLR 308, the movement must demonstrate 3 things. The movement must demonstrate that they encountered unpredictable circumstances in their efforts to serve. They must demonstrate that they could not effect service using conventional means, and that is each of
You make it sound like they had to exhaust every kind of type of service before they went to any kind of alternate service. That's not the law, though, is it?
I do not say that's the law, and if that's how you interpreted me, Your Honor, I apologize for my lack of clarity. The law is not that a person must exhaust the 120-day service period, wasting their time trying to serve a complaint they cannot serve. The law is that the court must present, in support of its 308-5 motion, evidence demonstrating that efforts would be futile. Would be. So in other words, of course the state of New York doesn't ask you to run around trying to serve in hand a person whose location you can't even identify.
So, counsel, to the extent that there was attempted service from 7 a.m. to 3 p.m. on the husband's alleged residence, to the extent that there was an attempt to serve the office, which was completely empty on a different day, the next day, and to the extent that there was an attempt to serve the defendant at his girlfriend's residence, are you saying that those three attempts were insufficient to establish impracticability, given the fact that as my colleague indicated, the definition of impracticability I think I'm pronouncing it correctly, is quite broad.
So yes, it is my contention that those efforts do not demonstrate impracticability, and I'm happy to explain why, if I may.
May I just ask, what about the allegation that your client was in Europe at this time, evading service?
So there is an allegation not denied by my client that for a brief period after the attempts at service, several days after, he departed for a vacation in Europe and then returned to the United States. The record is, may I finish
Please
my
continue,
answer?
yes.
The record is also replete with unrebutted testimony from my client that both he and his wife regularly, particularly during this time of the year, travel the earth. So he was not evading service, and there's nothing to suggest he was. He went on a vacation and then he came back. I think what's essential here, is that if this case were to stand with respect to Subpart 5, it would be the only case in this state where the movement testifies that she shares a New York County apartment with her husband.
But didn't he keep her out of that apartment?
I'm glad you asked. The answer to that question is an absolutely definitive no. The wife testified that the husband told the super of the building that she was not an owner of the apartment. She never testified that she was denied access to the apartment. She never testified that she sought access and could not gain it. And she, in fact, testified that both she and her husband resided there simultaneously. That is a red herring designed to create the false impression of impracticability.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. Jad Greifer from Cohen, Clare, Lands, Greifer, and Simpson. Just picking up on where my colleague started, which I think is noteworthy, that there was no argument from appellant that DRL 230 was not
Does it
satisfied.
matter that the defendant filed first in Florida? He did file his case the day before, right?
It does not matter who files first. There is no definitive rule that that's meaningful in either jurisdiction. There's no citation or case law that that is meaningful by appellant whatsoever.
Did the Supreme Court say anything about that? The fact that the case was filed first in Florida?
I think, if my recollection serves, that there were questions, and the sequence was laid bare in both our papers and respondents' papers, both to the court below as well as this court. My client was unaware that her husband had filed in Florida. She happened to file the next day. He was served first, long before she was served.
I'm sorry. Is Florida a filing state?
Meaning that who files first? Not to my knowledge, but I'm not barred in Florida, so I don't want to represent, but that is not my understanding. And the Florida judge, both as part of this record as well as substance of the record, has confirmed that she's going to defer to the determination of this court if New York retains jurisdiction. So she doesn't apparently think that's meaningful. I think you can conclude by inference. We applied for alternate service. There was not a single misrepresented fact, as Your Honors correctly noted. For 8 hours, there was attempted service at his office. Again, the next day, there was attempted service at his office. Attempted service at his home for 8 hours. Attempted service at his girlfriend's home for 5 hours. Again, none of these facts are denied. One, that he has a New York girlfriend, or that that was an appropriate manner to attempt service.
Counsel, what about the indicia that they've been resident in Florida since 2023, the tax forms? I know she changed her license back to New York, but she did have a driver's license in Florida for a while, correct?
There is no denial that they were also residents of Florida, but as this court has made clear time and time again, while a party can have one domicile, a party can have multiple residences. So yes, they do have a residence in Florida, and that is not meaningful for this court's DRL 230 analysis, which this court in Merjani in 2014 and this court in Jindal in 2008 made clear that the standard of review for residency under DRL 230 is a permanent residence in New York and return with regularity. Doesn't have to be the only residence, doesn't have to be the exclusive residence, doesn't have to be the residence where you spent the most days. And in fact, this court has found in Davis, when someone only returned 56 days in the prior year, that was the second department, so not this court exactly.
In this case, I guess between August of 2023 and August of 2025, the husband admitted to 179 days in New York.
That's correct. That was his admission.
So that's a little less than 25%.
But that's his admission, and that's certainly returned with regularity, factually more than the cases upon which this court has elicited or elucidated the standard that you have to have a permanent residence in New York and return with regularity. There's nothing in the statute or any of the decisional law from this court that says it has to be the residence that you live at the most. And as this court is aware, I believe from Unane, if I'm pronouncing that half right, the idea is under DRL 230 that we don't allow the courts to become a divorce mill for people who have no connection to this state. These people have lived in New York for 30 years. They've owned this particular residence for close to 14 years. This particular residence, this luxury four.
That's no question. It just seems like in the last few years, potentially, there's some argument that they have foregone residence in New York. Their son went to school in Florida. You know, they spent a lot of time in Florida. I know the point that you're making is that you can have more than one residence. We're not talking domicile. I don't think the other side is arguing domicile. But
so, yes, they did have, for the reasons that their younger son was having trouble in school, getting bad grades, not in with a good crowd. One of their sons continued at Dalton in New York, in Manhattan. The other was enrolled in a school, I think it's called the Benjamin School, in Florida. So they had one son in one place, one son in the other place. They spent the entirety of their summers here. They spent vacations. They had a very significant connection to New York. It does not matter that if in a particular year they had more nights in the bedroom in Florida than more nights in the bedroom in New York.
and there's a second residence in New York, is there not?
There is. They're building they have a Hamptons home that there is under a massive $20 million construction, and they've also maintained as a weekend home their Connecticut home. And as Your Honor pointed, it was not found by the lower court, but my client is a domiciliary of New York. Once you are a domicile of a state, New York, that is not given unless there is an affirmative, demonstrative intent to give that up. So even if the husband decided, you know what, I'm a domicile of Florida, that doesn't reach the fact that my client can remain a domicile of New York, and there's plenty of case law that says, you know, a wife doesn't have to follow the domicile of her husband.
True. Thank you, counsel.
Thank you.
My opponent hit one nail on the head. It is not definitive the number of days that a person spends in any given jurisdiction. We never said it was, and in fact, it is not. However, when the court considers DRL 230 compliance, what it actually does, if you look at the entire body of relevant case law, is the court looks at two bodies of evidence. Body of evidence in one is during the statutory look-back period, and not 30 years back to kindergarten. It's a short period for a reason, because people actually can leave New York. During the statutory look-back period, is there a jurisdiction in which you spent more time than any other? If it isn't New York, presumptively you have not satisfied DRL 230, but as pointed out by my opponent in referring to the Davis case, you can still save DRL 230 jurisdiction by demonstrating that while during the statutory look-back period you may have been in another state more often, you nonetheless
I don't see that in the cases that I looked at, counsel. In Wittich, it just said a party may maintain more than one residence and still be deemed a New York resident if he or she has resided in New York for with a substantial degree with continuity and permanence. And Morjani 2014 just says maintained a permanent residence in New York and returned there with regularity. And I have a whole bunch of other ones, but here we're talking, as my colleague indicated, 179 days in a 2-year period, which arguably satisfies Section 5 of 230. Why not?
It doesn't satisfy it, Your Honor, because...
Where does it say, what case says that you must be in New York a greater time than you spend anyplace else?
So there are First Department cases, including Wildenstein and Westlock, which articulate the following standard. The record adequately demonstrates the parties regularly returned as part of their active lifestyle to reside, by the way, not visit, but reside in their New York apartment, and that there was no other place to which they returned so frequently or with such regularity. And I submit that that standard...
That's the standard? That's what you're saying?
I am saying that that standard and the one articulated by Your Honor can peacefully coexist. The three cases Your Honor referred to, which are also cited by my opponent, do not address in any way or even suggest that there was a place to which the subject individual returned more frequently than New York. What the cases say is that person spent a portion of the look-back period in India. I submit that if that portion had been more than half, those cases may have come out differently and certainly would have addressed that fact. What one can draw from those very short opinions is that the person challenging DRL 230 jurisdiction did so by pointing to the presence of one or both parties in another jurisdiction less frequently than New York, but kind of a lot. And so the day count didn't need to be reached.
Speculation doesn't work.
I am speculating, Your Honor, but I have to harmonize the cases. They all exist. They cite each other. So I don't think that...
You cite them to us, counsel. Thank you. Any other questions? Thank you both.
Thank you.
People v. Luz Hernandez. Please.
Good afternoon. Karen Brill with the Office of the Appellate Defender for Ms. Hernandez. I know the District Attorney's Office didn't come to argue the case. I just wanted to make sure to highlight two issues with this sentence that illustrate why this court should reduce it. First, Ms. Hernandez was sentenced much more harshly just because she was not federally prosecuted.
Just because she what?
Not federally prosecuted. There were 9 total women who
The
were...
federal defendants younger?
Some of them were. Ms. Hernandez is about in the middle of the age range, which is from late teens to the oldest was 26. Ms. Hernandez was 24. And another one of those code the 26-year-old got a 30-day jail term. Ms. Hernandez got over 2 years.
Did the other defendants also have a bachelor's degree and a master's degree?
Again, the 26-year-old that I'm referring to also had an advanced...
I'm sorry, it's really hard
so
to
sorry.
understand you. with
No,
the
I'm
math.
sorry.
There's nobody around you, so you could go like this.
I'm going to keep it on, but I'll try to speak more clearly. The 26-year-old also had an advanced education. The U.S. Attorney's Office argued that as a sentence enhancement in the federal case, and the federal court rejected that there. I think the reason being that they saw that saw these cases all together on a continuum, that the way that this predator operated meant that these really were minimum culpability offenses that warranted minimum sentences. Ms. Hernandez was the only person prosecuted in state court, and without that perspective, without a judge who knew that she was even imposing a disparity.
Were any of the other defendants, and they weren't co-defendants, by the way, so the defendants separately prosecuted, but were any of them substitute teachers or employed as a direct support professional for special needs children?
Not to my knowledge, Your Honor.
So how do you compare her to the other defendants who were in this? I don't even know how to characterize it. The allegations here are beyond shocking.
I think that these were 9 women. They all have individual case circumstances. I'm not denying that. I'm not saying they're identical people. But the broad spectrum of this for all of these women was that they received substantially less prison time than Ms. Hernandez, the only person who got more offended against 2 children in an extended course of conduct.
Didn't she have more responsibility and more knowledge with respect to children as to what her acts concerning her own child might cause that child, what harm that could cause that child? Wasn't she in a unique position?
I don't think she was, Your Honor, because I don't think this is about what she intellectually knew. She knew it was wrong. She said that. But the course of manipulation that happened in a very short amount of time that night.
But at this time, you're not really even arguing about in terms of incarceration. The defendant is on parole, is she not?
Yes. If I could just speak one sentence about the parole issue. The reason that is so urgent is that every day she is on parole, she is stuck on the SARA movement restriction, and that's a restriction this court says stops people from finding stable housing and employment. It is not helping her, it is holding her back. And because of that, I would ask this court to reduce the sentence.
Thank you, counsel. Scanlon, the South Street Seaport. Give me a second, counsel.
Sure.
Okay.
May it please the court, Jessica Smith for Plaza and Ocean. So Plaza should have been granted an order of contractual indemnity over Kenville. The court below already determined that the relevant indemnification provision was triggered and that Plaza was in fact an indemnity identified in the contract. The only reason why they denied Kenville's motion was issues of fact as to their negligence. However, at the very least, it should have been a conditional order of indemnity because that's issues of fact alone was not a basis to deny it here. There is a savings provision in the indemnity clause, so and no indication that any action on the part of Plaza would have been the sole cause of plaintiff's accident here.
Speaking of your client's alleged negligence, now, Mr. Bunzel could stop work if it was in violation of OSHA or DOB standards. He reviewed the work site. Why doesn't that create some potential issue?
So generally, the authority to stop work on its own is not sufficient to raise an issue of fact as to supervision and control over the work here. So that alone, and I have cases that I've cited, Singh and Hughes, that go to
Here
that.
we have an extension ladder that is split in half, and according to the testimony of the plaintiff and one of his co-workers, for the course of perhaps 2 weeks, that upper extension ladder was being used separate from its bottom half, notwithstanding the fact that it didn't have little feet or rubber on the bottom or anything like that. And surely a violation such of that would have come to the attention of the plaintiff's site supervisor.
So this isn't the plaintiff's site.
Plaza,
Right, so,
sorry.
Plaza is the general contractor here, so, okay. Just moving on from that point, so the use of the two pieces, the separated pieces of the extension ladder, that's actually an unsafe work practice, and the Court of Appeals had said that even if they had notice, notice of an unsafe work practice is not sufficient to demonstrate supervision and control. Had the ladders been used, the portions been used together, there wouldn't have been an issue with that.
The construct here is that Kenville is responsible for this, right?
That's correct. In fact, it's one of their contractual duties to provide ingress and egress.
They're supervising his work.
Correct.
presumably
And there's,
supplying his equipment.
that's true. And there's no plaintiff and his foreman both testified and they both confirmed that all instructions and equipment would have been supplied by Kenville for this work. I know Kenville does say that they didn't own the ladder, but one thing is absolutely clear, Plaza did not own the ladders. Unequivocal testimony to that fact. So they didn't have control over this particular device here enough to be given a duty in order to remedy it. They also Bunzel actually testified that he could ask the employer to remove a piece of equipment from the site, but he actually couldn't remove it himself as a worker for Plaza. And what's actually interesting here is after the accident, plaintiff's coworker testified that it was a Kenville worker who in fact removed the ladder from the site.
You say in your brief that Kenville was the only trade on site at the time. Where is that in the record, or what do you rely on for that assertion?
So there is actually a daily log that identifies Kenville as the only ones. The Bunzel actually testified that they were the ones doing the connection work at the site. Because of the nature of that work, there wouldn't be other entities there. They were also the only ones that would have used ladders. Plaza did have laborers, but they were limited to being on the ground floor picking up construction debris.
I see. So there were some plaza workers on site on the day of the accident or not?
Yeah, there were, and I'm sorry, I thought when you meant by you meant trades, since Plaza is a contractor, I did not
see.
include them in that. So,
Thank you.
okay, if there's, really, the only other thing that I would want to highlight is that in the same case, there was even more direct connection here than anything that you could really explain in Plaza's action, and still that wasn't sufficient. So just the idea that they could stop work or observe a condition in and of itself is not enough. And I also want to point out the distinction from Herrero, which Kenville relies on in their brief, is here that as I mentioned before, they did not have control over this piece of equipment. The GC and Herrero did admit that they actually could have removed the defective equipment themselves. So if there's nothing else, I'll reserve everything else for rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, William Kazmierczak on behalf of the plaintiff appellant. It's our position that the lower court erred in...
Your client concedes, does he not, that he knew using a detached extension ladder was a dangerous thing to do?
After the fact, yes. Before the fact, he said he did not realize it was unsecured.
And wasn't there another ladder that he had used in the proper ladder only 300 feet away?
Yes, Your Honor. But this ladder was provided to him to use as a way of getting to his work area. It was used by his coworkers, by his partner. It was a ladder that they used on site. It was the top half of an extension ladder. It was not secured, and it lacked feet.
So going down, he used an orange ladder, and going up, he used a blue ladder.
Yes, so we used the orange ladder to go find the bolts, and the bolts were by the blue ladder.
And the blue ladder, if I'm correct, had some type of label that said, "Caution, this ladder is not designed for separate use." Is that right?
That's correct. These ladders are not meant to be separated.
So to the extent that that warning was there, and I believe the plaintiff and his coworker both testified that they knew that the ladder should not be used, how do we get around the sole proximate cause issue?
Because the ladder is unsecured, it lacks feet, and therefore the lower court found the prima facie violation of 240, the plaintiff cannot be the sole proximate cause.
But the ladder would lack feet by definition because it's part of an extension ladder, so it fits, one part fits into the other, right?
Yes, and it's on the owner and the general contractor to provide a safe equipment for the workers to use.
Counsel, isn't this like Bianca Neto, the Court of Appeals case, where they found an issue of tribal fact, but they wouldn't find for the plaintiff, where the plaintiff used a kind of sketchy means to access the work site? In this case, there were alternate means for your client to access the work site, correct?
There were, yes.
So why isn't this an issue of fact about sole proximate cause?
Because the violation is in the ladder being unsecured. It's an unsecured ladder that was
I know
provided.
the ladder was there, but you have so many other things that your client seemed to be cognizant of the fact that it was unsafe. He had other means of getting to the work site. So why isn't that Bianca Neto? I mean, it may be that you'll prevail at trial, and it'll just be a matter of comparative negligence. But I don't know. He was making the choice at that time. It seems like it's at least they have an argument for sole proximate cause.
The ladder was there, provided for him to use, and it wasn't a shortcut. It just happened to be closer to the bolts you had to get for the work. That was.
If
Does it really
if
provide-
an individual knows that the ladder he's using is dangerous, he can get summary judgment under 241?
He testified the idea of a top half of an extension ladder is dangerous, but before it, he didn't know it was unsecured.
But he knew he wasn't supposed to use this ladder for the way he was using it.
He did not know he wasn't supposed to use it. He watched his coworkers use the ladder for 2 weeks prior to the accident.
Anything else you'd like to add, counsel?
And besides that,
We have another question, actually.
sorry.
I just want to be clear, he wasn't instructed to use that ladder to go up or down.
He wasn't instructed to use or not to use that ladder.
Okay. He just did it because it was 300 feet closer to him.
Yes.
Thank you.
And the second point, we believe the lower court properly found the plaintiff's version of the accident was uncontroverted. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Jerry DeCamp for the respondent, Kenville United Corp. Just to briefly go through, the lower court properly found an issue of fact with respect to the sole proximate cause defense on the 240 claim, based upon the fact that the plaintiff knew that other safety devices were available. He had been using it for approximately 2 months, which was the orange, fully extended and secured ladder at the front of the job site. And he admitted under oath that he used that broken ladder, which he knew was to be broken because it was approximately 300 feet
When you say
closer.
broken,
And-
I just want you to parse your words.
Sorry. It wasn't, it was an extension ladder that was
Separated is
taken
different
apart.
from broken, right?
It was separated.
Okay.
So it was not being used in the manner in which ladder is intended, correct. Also too, with respect to the, there being a second ground to deny the motion is also, just because it's an unwitnessed accident doesn't mean that their motion there should be denied, but there are 3 witnesses who all spoke to plaintiff on the date of the accident, immediately after his accident, and all testified that plaintiff never said that he fell from this ladder, never said that a ladder was involved with his accident, which creates issues of credibility for the trier
It wasn't
fact.
entirely coherent either, right? Because he had a head injury.
Wasn't he concussed?
There's no medical record submitted in support to say, to use a noseworthy doctrine or something else
Everybody
to that
said he was
effect.
dazed and incoherent.
I'm sorry, Your Honor?
Everyone said he was dazed and incoherent.
Well, they said that he said he didn't know what had happened, and now,
Was there another version of what had happened other than the one that we're presented with now?
no, Your Honor, there was not. It's just this version now came up in the lawsuit during his testimony, but it had not been provided before to his coworker, his foreman, or the plaza site superintendent.
So basically, the version that we have in front of us now is unchallenged.
Yes, but we still take the position that's an issue of credibility as to one day, immediately after the accident, he could not give any information with respect to what happened, and it's for the trier of fact to determine whether or not this accident did in fact even happen in the way that he now contends.
He had a big bump that they all saw.
Again, there's, but a big bump could have happened any other way. How is it now? He's got a very specific, detailed account of how it happened. Also just want to address briefly the third-party claim, the denial of Plaza's request for contractual indemnification against Kenville, which was also properly denied, and we do believe that Herrero is directly on point, which came down from this court, and Plaza's distinction that their superintendent did not have authority is incorrect based upon Mr. Bunzel's own testimony. He was specifically asked, if you observed a worker working on a separated extension ladder, would you stop the worker from using it? And he said yes. So he did have that authority. He was also asked—
Wasn't that typical general contractor, construction manager authority?
But they're saying that Herrero doesn't apply.
Is there any a construction manager or general contractor that wouldn't have authority to stop a job?
They generally do have authority to stop the job.
There's nothing unusual about the authority. There's nothing different about the authority here than in all the other cases that we have, in like Coca-Bianca, that there's this authority.
Well, in here, because that goes under the analysis when you're just talking about means and methods of the work, but here, this is more of a hybrid case, like it's addressed in Hierro, because we have a defective condition, because that ladder that he was using was not Kenville's ladder, and therefore it's a defective condition.
Refer to a defective condition in the premises and the nature of the premises, not something which relates to the means in which the job is being done.
No, not according to this court in Herrero. No, there was a defective scaffold being used by the plaintiff when he fell. It was not his employers, and the court analyzed that as being a defective condition on the site. I'd agree with you, Your Honor, if it was Kenville's scaffold, because then that is the manner, means, and methods by which they had their worker perform the work. But when it's a separate condition on the site that is not the property of the employer, then it is a defective condition, not a manner, means, and methods implemented by the employer, as they did not direct him to use that ladder.
Thank you, counsel.
Thank you.
Very briefly, in response to Kenville, the Herrero distinction is that the supervisor could not actually remove the object, the scaffold, the ladder here, with his own authority, right? Like the supervisor could have done in Herrero. But just moving on, I want to say this is exactly like Bianca Nieto. It essentially dictates what we need to do here, which is affirm that there are issues of fact. Mercado is also directly on point. It's the same exact thing where plaintiff takes a shortcut instead of going to the ladder that he knows is secured and is safe and that he's always used. You know, plaintiff makes a plethora of admissions here. He could have seen the top of the ladder, he could have seen the bottom of the ladder, but he just essentially wasn't paying attention. But he knew that others had used it, and he knew it was a separated extension ladder, and he knew that that was improper. So this is pretty much the textbook case for sole proximate cause here. It doesn't matter that no one told him not to use it, because that's actually not a requirement of sole proximate cause. You only actually need that for recalcitrant worker. So there's really no basis for a reversal here. Just moving on to the second alternative relief, that alternative point. So it's not that his version is uncontroverted, it's that the circumstances surrounding the accident are in dispute, raising an issue of fact just as his credibility. So the jury needs to assess whether they should even believe plaintiff's version that this accident happened. And that's Vasquez-Tinio is a case that we discuss in our brief, and that's just about the height of the ladder if you accepted plaintiff's version in that case.
You don't have any evidence that the accident didn't happen. It's just you're saying, well, the plaintiff says the accident happened and we shouldn't believe him.
Well, plaintiff says the accident happened now in this particular way. However, you know, as Canville pointed out, he spoke to numerous people that day, and they all said that he never mentioned that he fell from the ladder, and he said he didn't know how he received his injury. And I just point to the one case, which is Preldilaki, and that is a case that involves somebody who was under the influence of morphine when he allegedly gave his prior statements, and then that just goes to, you know, the weight. It's not determinative, the fact that he may have been concussed. So just if there's no other questions, I'll rest on my brief.
Thank you, Counsel.
Thank you.
Your Honor, putting the blame on the plaintiff would be saying that it's his fault the ladder was there, his fault the ladder wasn't secured, and that's not the case here. This ladder was provided for him to use. It wasn't a shortcut. It was more convenient for him to get back to his work area, which his coworkers and other people on the job site were using.
Anything else?
Thank you for your time.
Thank you very much. Thank you all. Reeves v. Foundation for Child Victims.
Good afternoon. I'm Michael Lesher, representing the defendants' appellants. As you know, this is a case involving a refusal of the motion court to dismiss the defamation claim against my clients, and there are a number of arguments for reversal I laid out in the brief. I just want to highlight a couple of things. First of all, this court's recent decision in Isali versus Guard. That's something I didn't argue in my opening brief because the case is so recent it hadn't been
cited in your reply brief.
I'm sorry?
You cite Isali
In the reply brief, yes, but in my opening brief I didn't because it hadn't been decided yet. Now that case shortcuts a lot of the argument on the proper standard to apply to in this case because under Isali it's absolutely clear.
Let's assume that you know, the amendments to the anti-SLAPP law are applicable here, and the Supreme Court was incorrect. Doesn't the complaint make out actual malice anyway?
Okay, the plaintiff made this claim, but it's wrong for two reasons. First of all, that is not what the motion court held. The motion court clearly did not apply the actual malice standard. The motion court said she was not going to. The judge said she would not apply the standard, and that had not been met because these new amendments weren't effective then. The Isali case, I think, requires reversal on that point. So
It's a motion to dismiss. I mean, so can we can look at the Second Amendment complaint just as well as anybody. And determine whether or not actual malice is made out. And you know, there's a lot of fairly inflammatory statements made by your client.
Okay, but let me answer that.
Let me ask you a question also. Your client said not-for-profit, right?
Yes.
Did the wife pay to have them post these ethics complaints?
I know the wife, my understanding is the wife paid the foundation. I don't know exactly what the payment covered, but there was
so
a
money
payment
changed
made.
hands, and then
yes.
these ethics complaints, quote-unquote, happened, correct?
That's right.
Okay, please continue.
I wanted to make the point that simply alleging in the Second Amendment complaint that absolute malice, I'm sorry, that the defendant was acted with actual malice doesn't work, right?
Where
Because
does the fact that at some point the plaintiff is granted custody of the children, right?
right.
Where does that figure into all of this in terms of malice and the relief you seek?
I'm sorry?
Where does that figure into malice and the relief you seek? After all, you say all these horrible things about the plaintiff, and yet family court ends up granting him custody.
That's right. Well, that's exactly, okay, I can answer that
Isn't there
question
sort of
together with the previous one.
a lot of tension between?
Yeah, no, look, let's not beat around the bush. These are strongly worded statements. But there's very solid New York case law, one from this, Freckman v. Gutterman from this court, and Steinhilber versus Alphonse from the Court of Appeals that make it very clear that the heat of the comment doesn't prevent it from being perfected.
Let's talk
protected
about the
opinion.
ethics complaints.
Right.
To which commission or committee or body were the ethics complaints made?
They were made to different people. There was a complaint.
No. So we know that if you're an attorney, you make a complaint to the Attorney Grievance Committee, right, in New York. Okay, so to whom or to what were the ethics complaints made?
I think what you're getting at is these were publicly distributed comments. Am I reading?
No, I'm not asking that.
I mean, they were sent.
The complaints are characterized, self-describing as ethics complaints. So my question is, to whom or to what were the ethics complaints made based on violation of what ethics rules, regulations, or laws?
I don't think that Jill Jones Soderman was using the word ethics.
It's a zero,
in
isn't
a
it, counsel?
technical way.
Isn't your answer that there were simply self-denominated ethics complaints? There were never any ethics complaints? And doesn't that pose a problem for you?
I don't think so, because a public comment criticizing a judicial action is a protected opinion.
An ethics complaint is an entity unto itself.
Yeah, in other words, there's the Commission on Judicial Conduct that you brief about
Yes.
judges to. There's the
Right.
Attorney Grievance Committee that you brief about lawyers to. That didn't happen here.
She wanted to beef to the public. She wanted to let people know what had happened in this case that she thought
So there
was
were
wrong.
no ethics complaints made.
Not in this, not in
So
the
it's
formal,
not truth,
not in the formal
is
sense.
it? You know, truth is a defense to a defamation case, but there's no truth in that,
Well,
is
this
there?
is just a denomination. I mean, this wasn't the substance of what she said. What the plaintiff alleged and what the motion court upheld had to do with the substance of what she stated, saying that these things were actionable. It's my position that they were not actionable. That's outlined in the brief, and I see my time's up, so.
Thank you, counsel. Your time rebuttal.
Good afternoon. Alan Lewis for Mr. Reeves. There are 5 fatal defects in
Counsel,
the...
before you start, we talked about the Easley case just now. The Easley case came out before your brief was filed. Your firm was on the Easley case.
It was my
How come you
case.
didn't cite it in the first place?
I'm sorry?
How come you didn't cite it in your brief?
Because it doesn't matter.
Doesn't it say that, that the amendments to the anti-SLAPP law do apply in the case?
The actual malice pleading standard did apply. The complaint pleads actual malice. That's one of the 5 reasons why the decision below is correct. I'd like to go through all 5 reasons, and I'll get back to that, Your Honor. The first and the most fundamental reason is that the defendant's motion is procedurally defective because in a decision that the defendants did not appeal, the lower court denied an anti-SLAPP motion by the defendants whose factual allegations and legal theories are identical to the motion that the defendant is bringing back to this court. The defendants did their best to hide the fact that this is a second version of the same motion by not including documents 127, 128, and 129 in their appendix or discussing them in their brief. But in those documents, the defendants make an anti-SLAPP motion to dismiss and a summary judgment motion. The facts in support of that motion are word for word identical to the motion that the defendants make 2 years later. But because defendants have already made this motion, the court has denied it and said these facts require discovery, citing the provision in 3212 that allows a court to deny a summary judgment motion where the facts require discovery. That happened. They didn't appeal the decision which said this anti-SLAPP motion is denied pending the completion of discovery. By the way, they've since tried to frustrate discovery. The lawyer for Ms. Soderman in the lower court moved to withdraw moments before we were going to take her deposition. But that's the most fundamental reason why we shouldn't even be here today. Another problem is how the defendants have framed their appeal. They frame it as the lower court failed to demand of plaintiff clear and convincing evidence of defendant's actual malice. Now, a party opposing an anti-SLAPP motion doesn't have to prove anything by clear and convincing evidence. Instead, as this court held in Reeves versus Associated, the proof standard is, quote, intended to be less than a preponderance of the evidence. A third fundamental...
Counsel, did the defendant address substantial basis at all?
The words substantial basis appear absolutely nowhere.
And why or why not is that significant?
To quote Your Honor, in the Reeves case, well, first of all, the substantial basis standard lets the opponent of the motion know they're required to come forward with evidence that supplies a substantial basis. When the motion itself doesn't allege that the case lacks a substantial basis, it doesn't give the opponent of the motion the proper notice of what he's supposed to do. Now, as you wrote in Reeves, the concern that granting 3211G relief would give defendants carte blanche in the defamation arena is overstated because judicial scrutiny of the substantial basis factor is a sufficient safeguard against that concern. Here, there was no judicial scrutiny over the substantial basis factor because those words and concept appear absolutely nowhere in the lower court or even in defendants' briefs to this court. So, despite defendants' failure to invoke substantial basis, the documents that Reeves supplied to the motion court in response to the 3211A 1 and 7 motions are more than sufficient to demonstrate a substantial basis for his lawsuit. For example, and this is on page 340 of the appendix, the defendants referred to Mr. Reeves as having been substantiated for child abuse by ACS. That is an absolutely false statement. It was never substantiated for child abuse. Soderman looked at all of these documents. She knew it was false, and she said it anyway. And for the same reason, that also is yet another reason why there's no fair report privilege for this. The statements that she made are not fair and accurate. Instead, they grossly mischaracterize.
Counsel, you make that point very well in your brief. Any other questions?
Thank you.
All right, just a couple of points. Again, the fact that the plaintiff argued that he had proved substantial malice or alleged it in the second amended complaint doesn't make it the law. In fact, the law is very clear. Simkin v. Blank, I think I cited in the brief, says that factual allegations have to be taken as true in the context of a motion to dismiss, but not legal conclusions. This was a legal conclusion. So the motion court was not obliged to accept it. This court isn't obliged to accept it. The motion court didn't accept it. That's just a fact. The argument about this being a redundant motion, frankly, I don't think was even raised in the plaintiff's opposition brief. It wasn't part of the motion court's decision. I think it's a red herring, and I think likewise the whole issue of the...
Can you address your adversary's point that these statements were grossly mischaracterized?
Okay, so the only one that he really singles out is the one that he just mentioned, but I think if you look at what she actually said, it just tracks accurately, more or less, the sequence of events. There was a charge made against him for child abuse as well as a drug problem. Initially, CPS seemed to be backing that. Then there was an agreement between CPS and him in which they dropped the child abuse issue but did he did agree to the drug problem, which was, after all, a problem involving the child. But you know, you could say perhaps that the statement wasn't as clearly worded as it might have been, but since it begins by saying it started with child abuse and neglect, and then he agreed to a neglect charge, it couldn't very well be read as saying he had agreed to a child abuse finding. So again, I don't think that's a false statement, certainly when it's evaluated under the correct standard, which is actual malice. I don't think it rises to the level of being actionable. And that's true for the other statements as well. So, you know, again, just to make a point about that, I'm sorry, I see I'm out of time, unless there are questions.
You have 30 seconds, counsel, to finish the
All right, just by way of analogy, there is a book published by a former prosecutor called Outrage, 5 Reasons Why O.J. Simpson Got Away with Murder. If the plaintiff were right in his approach to these cases, you would have to say that that was actionable, that Simpson could have covered damages from the title alone because it said he committed a murder. I would say no. He knew that he wasn't convicted of murder. The reader would know that. The point was he held the case was improperly handled, and that's an opinion, and that's what Jill Jones-Soderman was arguing in this case. Not that the guy was adjudicated to have done all these things, but that he should have been.
Thank you, counsel.
Okay, thank you.
Thank you both. Tender touch via Nutzeg. Nuzeg.
Good afternoon. Andrea Caruso on behalf of Appellant VistaCare. This case is trying to overturn a judgment which was found by virtue of a fraudulent transfer, alter ego, under DCL and under 52.
Also, put the microphone a little closer to your mouth, please. Thank you.
Sure. I tend to be very loud, so I don't want to get in your face.
Be loud, please.
Fine, not a problem. So the fraudulent transfer aspect of this case requires inadequate consideration and insolvency upon the entity. The lack of consideration issue I'm going to start with. While the court doesn't explicitly in the underlying decision, which then by virtue went into a judgment, state what consideration he found to be not inadequate, he does reference or solely.
Counsel,
Yes.
$10 for a company valued at $22 million, I think, speaks for itself about the undervalue of the $10 consideration.
But that's also assuming that $10 is real. Every deed filed in the city of New York says $10 or for other fair and valuable consideration. It's not intended and never is intended to be a literal number. There's a bill of sale, there's a memorandum of understanding. Submitted herein were records, debts, things that were.
Does that mean that the judgment was satisfied? If $10 was just symbolic, then how come we have an issue here as to the non-payment of the monies that are arguably due to the petitioner, tender touch?
I'm honestly not following your question. The judgment was issued.
If $10 means something other than a company which had a very significant value was sold for nothing, and that their argument is that a transfer was made from basically family members to family members, spouses to spouses.
It's the same family members.
Same family members, same corporate structure, same everything except that the petitioner didn't get paid. How is this not how do you call it when you play?
Shell game.
Shell game, thank you.
So I don't think it was for multiple reasons, and I think the evidence that was submitted, for starters, this valuable consideration, valuation, there's really no evidence as to what the real valuation was as of the date of transfer. That's a question. There's a valuation that was submitted by petitioners that showed $27 million as of 2009, 8 years before the transfer. There's a separate valuation that was.
Which is for $6 million, which is still a problem for you. But let me ask you about something else. There's a finding of de facto merger, isn't there?
Yes, there is.
So your main brief doesn't address that, does it?
My main brief does not. We did do it.
So don't you have to lose because of de facto merger?
I don't think so, because I think the factors are all the same here. And the court isn't clear as to what they're relying on and if all of
De
them.
facto merger is the same as fraudulent conveyance?
I think that it requires a lot of the same considerations, yes. I think the consideration that was paid is something that has to be considered. I think the relationship between the parties has to be considered. The assumption of liabilities, which was very heavily argued, has to be considered. That's what the hallmarks of de facto merger require. They require certain factors which weren't even
But your
specifically
main brief
discussed.
doesn't address those issues, not until the reply brief.
Well, the factors are all discussed there. We discuss consideration, not solely within DCL. We discuss insolvency, not solely within DCL. We discuss them as concepts which equally apply to de facto merger or not. It's not limited just to the DCL. It's relative to everything. It was discussed in everything. In fact, the courts, when he found, and I printed it very small, when he found the de facto merger, it says, at the very end of the paragraph, he says, in sum, the transfer was designed to evade the award and Vistacare is liable as the receipt of a fraudulent transfer. He equates it back to a fraudulent transfer. So the fraudulent transfer arguments equally apply to the de facto merger argument. I would submit.
All de facto mergers are fraudulent transfers?
I would not say that. I don't know that to be true. I think in this instance, that is what the judge held. Whether that's true ultimately, I'm not here to say, and I wouldn't be in a position to say that one way or another. I think that the consideration that was paid here was in the form of debt. I don't think that's disputed. I don't think they were rendered insolvent. There was plenty of evidence, and I'm happy to stop if you'd like me to stop, or I can finish this one thought. There was evidence that was submitted that showed that there were accounts receivable, that money was collected, there was an outstanding amount to be paid on that. They weren't rendered insolvent. That was in the millions at that point. I'll reserve now at this point for my rebuttal. Thank you.
May it please the court, William Dorsey of Blank Rome LLP for Tender Touch. Picking up on...
De facto merger, one and the same with fraudulent conveyance?
No, they're different. A de facto merger is...
Did the Supreme Court treat them as one and the same?
I don't believe so, Your Honor. We introduced evidence that there was a direct correlation between the officers and directors and the operations of this business from one day to the next, and they were literally the same. And I don't blame my colleague here for her maybe mischaracterizing the record. This is the fourth or fifth set of counsel that has represented these same parties. But there is, in the record in page 37, it is clear that in a letter to the Department of Health, they listed that Rivka C and Rivka B were the 55 and 45% owners of these businesses, Tunuzeg and then Vistacare, that Brian Kleiman was the manager of both of those entities, and during their depositions, I confirmed that they had the same employees, the same beds, the same facility, which is, by the way, one of the largest skilled nursing facilities in the entire state of New Jersey. And the $27 million appraisal that counsel tries to run away from was an appraisal that the Kleimans ordered in a case where they introduced that as evidence to support their valuation.
2009, is it not?
It was introduced in evidence in 2016. I agree that it's a little bit dated, but the one that they now try to point to was the one proffered by their opponent in that litigation that they ended up winning. The other thing I want to point out, again, sort of maybe a misunderstanding of the record, is that there was supposedly this accounts receivable that were left at Tunuzeg. First of all, that's not consideration, right? The only consideration is the $10 reflected in that account. They never proffered any evidence of actual money. The ability to not operate a business is not consideration. They also own the landlord and so have the ability to forgive any rent that was due. But
You're saying owned and not owed, right?
yes, yes. And then when you come to the $2.9 million that's supposedly on the books, we asked for evidence to support that number, whether it was collectible. We would have gone after that if there was real assets there, of course. They never produced the accounts receivable, never produced any evidence that would allow us to do that. All of this was on the record before the court when it made its determination that there was...
Has your client collected any of the money awarded by Supreme Court?
Not a penny, Judge.
How about the attorney's fees on the contempt motion?
None, none. Now,
Why don't you spend a minute talking about the contempt motion?
absolutely. I was going to turn exactly to that. We talked earlier about a shell game. The first level of the shell game was 300 Broadway to Tenuzeg. The second level was Tenuzeg to Vistacare. The next level of the shell game was a fourth entity, which is BSD. After the judgment was entered, we had restraints. Before the judgment was entered, we had a preliminary injunction that enjoined the Klymans and Vistacare from transferring assets outside of the ordinary course of business so that there would be money to collect. Because as you may recall, we had come up here before to get the affirmance of the first judgment against the first two entities. While we were finishing up against Vistacare, the trial court ordered that those assets be held, anything not spent in the ordinary course. All of those orders were ignored. The preliminary injunction, the restraints, the subsequent orders of the court. They refused to produce documents. They refused to sit for post-judgment debtor exams. And there's an accusation that the fees are somehow just related to the contempt motion. There was an express finding by Justice Cohen that this is related to all of the post-judgment conduct. If they had complied with, frankly, any of his orders, we would have just been able to get the money. This skilled nursing facility generates literally $10 million a month. All we had to do was go collect it from assets that should have been sitting there. Every dollar that we've had to spend was a direct result of the contempt of the defendants in this case. And so we believe we're entitled to recover that. By the way, there's also a
It
provision.
started with an arbitration, right?
It started with an arbitration.
Who are the parties to the arbitration?
The parties to the arbitration were tender touch in their principles. As you may know, under rabbinical law, there's a question about whether individuals are different from the corporations that they are behind. So the principles of those businesses were there, as well as the—
On both sides?
On both sides, correct. And then—
So the arbitration award was against the individuals also?
That's correct. But then, obviously, when we were pursuing it, we pursued it against only the entities. So if you have any other questions, otherwise, I'll return the rest of my time.
Thank you.
I have a few things. We are not alleging that the accounts receivable was the consideration. That's not the argument that's made. The accounts receivable argument is made to show that they weren't insolvent at the time, not that it was consideration for the transfer. Specifically, the memorandum of understanding dictates what happens with the accounts receivable. It's not a point of consideration that we are raising. It was other debts that they assumed in terms of getting them out of a lease. So I want to be clear on that because that was explicitly stated. I also want to say that we never had a hearing in this case. This case was done as a special proceeding to confirm an arbitration award. It was done only as a petition with opposition.
Counsel, you want to talk about the contempt?
I do. So Your Honor asked a question about whether anything's been paid. I want to be clear. There's a bond here. There's a stay and a bond. We have bonded this entire thing, so I don't want you to assume that nothing's been paid out of spite or anything.
Did your clients embark on some strategy to avoid paying the judgment?
No. We filed the contempt motion that was filed that resulted in these fees is problematic. One, the cases don't support this kind of finding, regardless of what Justice Cohen stated. The cases that even
Violating a court order cannot result in a finding of contempt of court?
No, contempt of court is appropriate where—
No. My question is, can't a judge find an entity or a person in contempt of court for violating a court order? Are you
Yes,
saying
we're
no?
not No. Yes, we're not challenging the contempt. We're not challenging the contempt here. My appeal does not challenge whether or not the contempt was correct. The only thing it challenges is the legal fees that were awarded as a result of that contempt. There's case law in this department about what can be awarded.
So you agree that the contempt finding was fine?
I'm not going to agree or disagree. I'm not challenging it. I'm not here to challenge it. It's not my position to say whether it's fine or not fine. I opposed it, so obviously I believe it's not fine. But and to advocate for my clients, I have to say it's not fine, of course. But the challenge here is to the legal fees only, and what resulted— may I just finish this one thought on the legal fees? What resulted was legal fees on the entirety of the post-judgment period. There were motions within that time period that counsel lost, and yet they still got legal fees for that. There was rudimentary sending of subpoenas, which we all do post-judgment to try and get. They got legal fees for that. That's not the purpose of a contempt motion legal fees award, and that's what I'm here
Judge
arguing.
limit the legal fees?
I didn't hear you, I'm sorry.
Didn't the judge limit the legal fees?
All he did was cut $20,000 off without justification as to what it intended to cut off. So I cannot tell you yes or no. Yes, there was a $20,000 deduction. What it is for specifically, I cannot tell you because the decision is not specific on that point.
Thank you, counsel.
Thank you.
Both. Sonogo v. Giacomini.
Good afternoon, Your Honors. Scott Pearl, Buden-Reisman, for the appellant, Mr. Sonogo. It's our position that the trial court below erred in relying upon a biomechanical engineer's unsworn report,
Right.
which
Did you preserve that issue, though? That's the first thing we need to get around.
I believe it's always preserved, Judge. I believe that because the defendant below, the respondent.
Always
below-
preserved?
I do, because
Okay.
because otherwise we have the Court of Appeals has continually said, excuse me, that in order to get to the sufficiency of the plaintiff's opposition to its defendant's summary judgment motion, the defendant first must come forward with admissible evidence to establish a prima facie entitlement to that judgment
Yeah, but you got to
as a matter of law.
admissible evidence. What about, they cite some cases, for example, Sanchez v. Oxen. There, we assume that the burden had shifted to the plaintiff to address causation based on the engineer's unsworn report, since the plaintiff did not object to the form of the engineer's report. In other words, it was allowed and considered by the court. So,
Judge, I would say that all the cases cited by the respondent are distinguishable. And if you're pointing to...
Why wouldn't there be a need to object to it? I mean, because if you make an objection, they can come back and say, oh, we forgot to provide the certification or the affirmation, and here it is in reply.
Well, Your Honor, and to your point, this court has ruled that you cannot cure the unsworn report, specifically an engineer's unsworn report, in reply. And the report that we're looking at here goes beyond just a lack of a certification. The report is riddled with hearsay. The report's findings, the experts' purported findings, are based upon measurements, data, photographs taken by other unknown, unidentified individuals.
Well, let's talk about the photograph with the scratch on the car, which Mr. Sonogo said he recognized this as portraying the damage on his car.
Correct.
So whether it's authenticated or not, it doesn't matter. Your client recognized and said, yes, that is the damage on the car.
Correct, Your Honor. But the cause of that could be two different things. You have to take that into account the fact that we have divergent testimony. Each individual, the driver of the truck, Mr. Sonogo, both indicate that the other one was moving and the other one was stationary. Okay, so we have opposite positions on who was moving and how that even could have happened, the scratches on his vehicle.
But I don't
then
think
the court,
Mr. Moore was the only one who said if the truck had moved, the lines would have been circular. I don't think he was the only one who said that. So I believe a police officer said that as well.
No, it's not the police officer, Your Honor, but it's a good point. But if you look at the decision below, the court clearly relies upon Mr. Moore and starts off saying, based upon the findings of Mr. Moore, I find that the defendant has basically met their burden.
Thank you, counsel. You have time.
Thank you.
May it please the court, Karen Newworth for respondents. You've mostly, Your Honors, have mostly brought up the points that I was going to bring up, so I guess it's good that I'm speaking very shortly, but I will highlight the fact that we have straight parallel marks. We have the knowledge of common basic physics that if two lug nuts are moving on a truck's wheel, that it's going to make an arched mark. And we all know that since it was straight marks, that it's not possible that the UPS truck was moving at the time. Therefore, it must have been the car that was moving past that. We know this, and yes, Engineer Moore confirmed this using things like the photograph, which was essentially authenticated by Mr. Sinago himself by him saying, yes, this is the damage that was caused. So we have sufficient information and evidence for which the court could say, this is summary judgment. There's nothing left here. There's no issue of fact. I did want to point out one thing, which I'm hoping Your Honors will uphold this decision because I think it was appropriate, but if it was to reverse, there was a second part to this motion based on serious injuries, and then it would have to be remanded for the court to determine whether there possibly were any serious injuries
Are
in
we
this case.
required to disregard an engineer's report that's unsworn?
No, because as I think it was you who said in the case of Sanchez cited in my brief, an unsworn report was able to be used to shift the burden. It doesn't have to be, especially in a case like this where there were sufficient indicia of reliability based on the engineer's stamp and his statement of scientific principles that were followed here. And the measurements, by the way, that were taken by SEA employees, not random strangers. If no other questions, then I will rest.
Thank you, counsel.
Thank you.
Stand on the brief, Judge.
You'll stand with your brief? Okay, thank you, counsel. (415) East 12th Street Housing Development Fund, V. Duran. Please.
Good afternoon, Honorable Court. Thank you for providing me with the time to amplify my brief while appellants are not here today.
Sorry, who do you represent?
I represent the respondents here, and that would be Erasmo Duran and Erasmo Duran Jr. So basically, just to sum up my brief, Your Honors, within the court below, the judge specifically found that he would not enforce defective notices of default or termination. The notice of default was missing the pages and the allegations that went from numbers 2 through 10. The total number of allegations included 1 through 11. So 8 allegations.
It's missing 1 page or 2 pages, or we never figured that out?
It's missing. It appears to be missing 1 page, Your Honor, from the notice of default. And secondly, from the notice of termination, as you'll note, that's detailed in the brief, there's no allegations of misconduct occurring during the cure period that's allotted to.
And it does say in the first page, I'm looking at the notice of termination now, that you have continued your harassment and deleterious and abusive conduct. So in other words, it does list all these things that happened not during the cure period, but then it says, and you kept doing them. Is that enough?
It's not enough under the law, and some of the cases that are cited in my brief, Your Honor, detail that, in that if there is no alleged conduct to have arisen during the cure period, then the action must be dismissed.
And what about his refusal to accept service
Oh,
as a waiver?
Thank you, Your Honor. That's a great question. So in this instance, there's no indication of who it was that answered the door. My brief details that Erasmo Duran works full-time and is a superintendent. We don't know who answered the door, what occurred in that manner. And secondly, as noted in the court below, that issue would be moot based on both the defective notice of default and the defective notice of termination, whereas the judge specifically stated that he would not enforce either of those and that it would be a moot issue for service.
Counsel, at record 182, the notice of termination at paragraph 12 says, in addition to the foregoing, you continue to yell and harass residents both in the hallways of the building and on the street. Frequently, you slam doors, scream obscenities outside of residents' doors, and play music loudly while leaving your door open, disrupting daily life in the building. That's not enough?
Your Honor, under the case law that we cited, we state that it is not enough, that there's no specificity as to that. And if you look at the underlying
What
complaint,
specificity is missing? What detail is
there's
lacking?
no resident is identified. There's, if you look at the actual document itself that they're purporting, There is no individual resident cited with an actual name.
Counsel,
It's
isn't it also just-
unidentified.
I'm sorry to interrupt you, but isn't it also just a verbatim quote of another paragraph in the notice of default?
Yes, Your
It
Honor.
said the same exact thing in the notice of default.
Yes, yes.
Okay,
Okay,
thank you. Anything else? Thank you.
okay, thank you.
Matter of Anthem Healthcare Choice Assurance, the Campion.
Good afternoon.
Please.
Good afternoon. My name is Stephen Reinhardt of Elman Freeburg, speaking on behalf of the appellant. There are a lot of names in the courts below. My client was referred to as Empire, so I'll use that shorthand today, if that's okay. Empire, the appellant. This is an appeal from an order of the...
Counsel, if you can bring the microphone a little closer.
Sure. Is that better?
That's better.
This is an appeal from an order of the trial court dismissing the Article 78 petition of Anthem.
The city's effort here was in order to save money, was it not? I mean, not only.
Yes, that's certainly one of the objectives.
One of the objectives was to save money. How does the proposal that you made reflect a savings to the city?
A proposal reflected savings of several $100 million.
How did you get to that?
We got to that by offering what's called a tiering method of designating a certain hospital as non-preferred, which would require a greater cost share.
That you'd save money, you'd force people to use that hospital, or they would use that hospital, the charges would be less. But is that what this program seemed? First of all, they were looking to save more than several $100 million, weren't they? Weren't they looking for?
Two answers to that question, Your Honor. One is that tiering, which I just described, was something that the city specifically asked the bidders to propose. Secondly, yes, the objective was to save money. We frankly thought we had provided that.
But the city, that board takes a look at this and says, in terms of saving money, your rating is a 0.
That's not the formula in the notice of intent to negotiate. And that is one of the two, I think, principal issues that we'd like to talk about today.
Where is the city's decision? Where is their conclusion that the proposal that you are making doesn't really have any savings for us, whereas the other proposals do, and therefore we're not going to make you a finalist?
We have not seen any of the calculations or analysis done with respect to Empire's proposal or anybody else's proposal that substantiates the conclusion that they saved X dollars and we didn't save X dollars.
But what in your documents shows this major savings for the city?
A proposal to the city, which reflects a savings of several $100 million using this tiering method.
Counsel, you saw in the city's brief that they say that your proposal wouldn't cut costs below the city's current healthcare spending. Rather, it was a sort of a retardation of how costs would rise in later years. And so that it wasn't really even addressing what the city wanted, which was a cut from its current healthcare spending. What do you say to that?
What we say to that is that we have not seen the math that the city...
Well, but they're critiquing your own analysis. So do you disagree with that characterization of your client's own analysis?
Our client's analysis was, yes, that going forward, we would save the city several $100 million.
Going forward, right.
Yes, but the problem is that the NOI reflected a specific formulation for awarding points. This was a point-based system, this procurement.
No, I know, you talk about the relativity to the best price.
Price.
That's what you say they should have done in this case, and they come back.
It was in their
and say,
NOI.
We're only doing that for people who are saving us any money on our current costs, and Empire didn't do that. That's what they're saying.
That's what they're saying, but to us, that is an illegitimate gloss or distortion of what the formula was. The formula was price, ranked and scored, based on formula using relativity to the best price.
So, counsel,
which means that
my understanding of the calculations is that they met that criteria to the extent that that entity that had the proposal with the greatest savings got 25, and that one that had no savings was a 0. Empire being a 0. To the extent that you say, we didn't know anything about this, we don't know how we were truly ranked, there was an initial submission, which was the 0 one, where the city said, I'm sorry, the Department of Labor said, this is showing us an increase in costs. And then there was a submission that showed a 2% decrease in costs to the city. So isn't that by itself an acknowledgement that you understood that you were in trouble, and that your ranking was down in the dumps?
We don't see it that way, Your Honor. Here's why. Because when you use the formula of relativity to best price, which is what they advertised, you would then take the lowest price proposal, getting all, in this case, 250 points, because there were 10 evaluators, 25 points each. The next lowest will get a proportion of that based on our ratio. It's a calculation. If the first proposal was $400 million and the second one was 500, you divide 400 by 500 and multiply by the 250 points, you get 200 points.
Where did you get those calculations from?
That's an example of how the relativity to best price formula works. And in fact, we cite below and in our papers an example of that from the New York State procurement guidelines, which explain what relativity to best price means. It means your relative awarded points relative to the best price proposal. Not
relative to the others. But is it off the mark here for the evaluators to say, well, you know, we don't really see that this proposal is going to save us any money, and therefore they don't get any points?
There was no basis in this NOI to work a forfeiture, which is what this ended up being. And what I think I'm hearing from Your Honor is that if you don't, in the city's estimation, which we still haven't seen, because we've had no discovery in this situation, there are no savings, then there's an automatic forfeiture, and Empire would not even be entitled to a proportionate share of the points based on its ranking compared to the winning bid. And that's 25% of the total points awarded for this procurement. We should have gotten, at the very worst, third place in that ranking and an award of points based on the relationship between our bid and the winning bid. That's the way that formula works. That's a well understood and accepted formula in the procurement business.
Thank you, Counsel. You have time, rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Amy McCampbell on behalf of the city respondents. Your Honors, it was entirely reasonable for OLR here to demand cost savings. As Judge Frank noted in the decision below, nearly every document in this procurement put the vendors on notice that cost savings was one of the key goals.
His main complaints, as I hear it, is that, look, you haven't shown us any documents justifying the conclusions that you reached, not as to Empire and certainly not as to the others. And I understand as to the others, you've taken the position, well, we're in the midst of a negotiation, we're not about to disclose that to you. But even as to Empire, that you haven't given them that information.
So OLR did put Empire on notice that its proposal was pricing a plan that was more expensive than the city's current plan. That was the email that OLR sent to Empire. That's page 1374 of the record.
So we saw that.
Yes.
And let me correct myself. I said Department of Labor, and it's the Office of Labor Relations.
Yes, Your Honor.
So was there a ranking? Was that ranking made known to all of the vendors who applied?
You mean the ranking of the different competing vendors?
Yes.
Not during the active procurement, no, Your Honor.
So it was a secret?
Well, the ongoing scoring was not disclosed to each vendor during the ongoing procurement as they were in competition. But again, OLR put Empire on notice that its pricing was resulting in a plan that cost more to the city.
He claims that the tiering would have saved hundreds of millions of dollars. Why is that? Why doesn't that count for anything?
Well, they're comparing that against a hypothetical future without the tiering. And the baseline is not projected future cost. The baseline is the city's current healthcare spending. That was made clear over and over again in the procurement documents, that the city wanted to save.
You wanted a lower cost right now.
I'm sorry, Your Honor?
You wanted a lower cost right now.
We wanted to go below what we were currently spending. And again, there's...
And was there a target number for that? Was it 10% or?
The price questionnaire and the procurement specified that the city was asking for vendors to submit proposals that shaved at least 10% off the city's current cost.
Or 11% if you were doing self-insured.
I'm sorry, Your Honor?
Or 11% if you're doing self-insured?
Yes, at least 10%, depending on the type of plan you were proposing. And there were costs in that price questionnaire that showed what the targets were and what you were expected to shave off those targets, depending on the type of plan you were proposing. So again, the vendors were fully on notice. And Empire submitted another plan, an updated plan to OLR after OLR notified it that its proposal was more expensive, and still didn't offer the city any cost savings. Now, what Empire is arguing is that they're arguing the only rational way to score the main component of the price savings category is by using this one specific formula from a state procurement guidebook, not binding on the city, and even that own
They say it's only illustrative, though. I mean, they weren't saying that it's binding on the city. You're saying that the state means for figuring out relativity of price is illegitimate? Because they're just using it as an illustration of how you do the calculation.
It's one way that perhaps could have been used, but it's not the only rational way to do it. And certainly it was rational for OLR to choose a method that focused on cost savings, considering that the overriding goal, one of the key overriding goals, was to achieve cost savings from the current baseline. And again, that was signaled by the very category, price/savings. Now, under Empire's, the formula Empire says we had to use, in their view, the only legitimate method to do this, it makes sense that they're saying that because that would have been much more favorable to them. I'll give you another hypothetical, Your Honors. Let's imagine that a vendor proposes a plan that is $1 less than what the city is currently spending, and Empire makes a proposal that is twice as expensive. They would get half the maximum points under that formula, even though it would be billions of dollars more than what the city is currently spending, whereas the other proposal will be less.
Can we talk about timeliness a second?
Sure, Your Honor. So
correct me if I'm wrong. Are there two issues with respect to timeliness?
Yes, Your Honor.
Timeliness challenging not the formula, but the whole makeup of the proposal, which had to be challenged within 10 days, which is a very, very short amount of time, if I may say so. And then separately, a timeline with respect to the rejection of a particular proposal, a presentation or a submission, if you will. Are there two separate timelines?
Well, they did bring Article 78, I believe, within 4 months of the denial of their protest, but that was not timely, as we argued in our brief, because again, there's the 10-day rule under the procurement board rules, and then there's the 4-month statute of limitations under Article 78, and that starts to run from when the terms that they're seeking to challenge in the procurement are known to them. And there's two cases from this court on point, the Legal Aid Society case and the Council of City New York versus
You're
Giuliani.
addressing right now the notice of intent.
I'm sorry, Your Honor?
You are addressing which timeline, which issue? The initial proposal, the initial request for information, notice of intent, and all of that.
Almost all of those procurement documents put them on notice as to the self-insurance point that they're seeking to challenge, and put them on notice as to the cities asking for trend guarantees, which they're seeking to challenge, and also to the extent that they're arguing there was a lack of clarity in how the cost savings component was scored. They also didn't bring any challenges with respect to any lack of clarity in the procurement documents when it was issued. So there is a timeliness problem for their challenges in all those regards.
And then as to their submissions.
I'm sorry, Your Honor?
As to their submissions, the proposal that increased costs and the proposal that did only 2% of a reduction.
The proposal they submitted, which they argued it would have been roughly 2% lower hospital cost than trend-adjusted renewal cost. So that's only making a representation about hospital costs only compared to trend renewal. They're not even arguing that their proposal would be 2% cheaper than anything else than that. So they've made very limited representations about cost savings. They have never argued, as far as I know, that their submissions would have achieved cost savings from the city's current baseline. And that is the key point here, Your Honors.
Thank you, Counsel.
Thank you.
May it please the court, Christopher Cafferone, Pillsbury, Winthrop, Shaw, Pittman for respondents, Emblem Health and United Healthcare. I just wanted to address Empire's repeated contentions that they made at the administrative level, at the Supreme Court level, and again here on appeal, that Emblem was unable to perform. That argument, that contention fails, and it fails at every stage for the same reasons. First, it's unsupported by any evidence. Second, It was denied by the OLR as being completely speculative and without any foundation. And importantly, it's incredible when you look at both the 30 years of incumbency that Emblem Health has provided, as well as subsequent events.
You were selected.
We were selected, and
Yeah,
the
so doesn't that end the argument? I mean,
it should, and the plan has been in place since January 1st of this year. It's continuing, coverage is continuing, and so we just wanted to make that point known, that the Emblem has been a trustworthy partner for the city. And what's important here, and the city emphasized it, the procurement documents, this was not a remedial procurement. The procurement was about cost savings. It was clear from the first RFI.
Cost savings that would not result in significant increases for the workers.
Correct, Your Honor.
So did you achieve that?
That the rational decision that the OLR determined is what's entitled to deference. They did a lengthy, methodical process and determined that my clients were the most advantageous to maintain and continue that best in class healthcare that Emblem, my client, had been providing, as well as meet the objective of a 10% savings.
Did you ever learn how the other entities were ranked?
Not to my knowledge, Your Honor. To my knowledge, there was no sharing of, as the city said, of the different bids to the other parties for obvious reasons. They're competitors in this industry. It's not surprised that we're seeing these attacks because we were the incumbent, we won the proposal, and there's nothing in the record to suggest anything other than that my clients were trustworthy partners that have been delivering exemplary service and met that objective of providing savings.
Thank you, Counsel.
Thank you, Your Honor.
Claude Millman for Respondent Aetna Life Insurance. Two quick points having to do first with the discovery request about Aetna's information and also the attacks on Aetna in the papers. So first, regarding the discovery issues, this court has said discovery is disfavored, and we cited cases on page 1624 of the record. And the second department has also said that discovery should be denied if it's prejudicial. We cited that at 1631 of the record. We also provided the affirmation of Tracy Pingalore at page 1639, which explained how if Aetna's information were provided to Empire, that would damage Aetna's future business. Also, the lower court said, as has been discussed, that Empire failed to explain how it was going to save $1 billion a year or $10 billion over time. And as a result, any kind of discovery would be irrelevant. The attacks on Aetna all relate to two items. First, they've taken pre-procurement materials that Aetna submitted and twisted what Aetna actually said. And in any event, those submissions were not part of the procurement. Literally, the evaluators were prohibited from reviewing those documents, and that's at page 1512 and 1514 of the record. And separately, they've taken a whole bunch of newspaper articles regarding Aetna, taken them out of context, ignored newspaper articles about themselves, about Empire. None of that demonstrates that Aetna would have been unable to perform. It's irrelevant in any event because Aetna did not receive the award, but most significantly, what we're seeking is simply that the disparaging comments about us not be considered, and thank you very much.
Thank you, Counsel.
A couple of things. The first is the suggestion, I think, that if the formula in the NOI, relativity to best price, had been applied, it would have been favorable to Empire. I'm not surprised to hear that's the way the system should have worked. We should have been awarded points relative to the best price. Secondly, it is absolutely clear that we have not seen, and no one has seen, the manner in which the city calculated the savings or calculated price for any bidder. And what bears this out is, number one, the judge below denied any discovery on that topic. Number two, in response to FOIL requests, we received nothing. And number three, the city in its own papers conceded that they haven't disclosed how they calculated savings. They said the following. After the evaluation, scoring, award, and contract process is complete, more information, including the price savings formula, can be disclosed. They said that in their papers below. It was never disclosed. The procurement is over, the contract's been awarded, the contract's been signed. We've never received that information. Secondly, and in addition, they refer to their calculation as cost savings off the baselines. That's a quote, cost savings off the baselines. That's not what the NOI said. NOI had a very specific formula, which, as you point out, is explained in the state's procurement guide and is well understood.
So, Counsel, if I may, the issue of timeliness, the city's position is that if you had a problem with the manner in which the proposal was made, the request for information, the notice of intent, and so on, you should have attacked it back then or challenged it back then, but aren't you doing this now because you lost?
Frankly, no. We were not aware of the misapplication of the relativity to best price formula or the evaluation of price until we actually saw the score sheets that were provided to us pursuant to a FOIL request. Score sheets showing a 0 that was automatically imprinted on the score sheets before the evaluators even got them. We didn't see those until we were taken out of the procurement, we received the FOIL documents, and that triggered the protest and subsequent Article 78 proceeding. So we agreed when we got the NOI, relativity to best price, we're there. But that's not what they use. They use cost off the baselines and a calculation which they conceded had not been disclosed, would not be disclosed till the procurement was over and the contract was awarded. And guess what? We still don't have it. It's a black box.
Did you demonstrate the ample need for this discovery?
I'm sorry, I didn't hear you.
Did you demonstrate the ample need for this discovery?
We
That
did.
it
We made
wasn't
an
speculative?
application to the judge below with affidavits, with a showing, and it was very limited discovery. It was really just discovery into how did the city calculate cost savings and award points pursuant to the NOI, pursuant to the formula relativity to best price. Just so it's what you did for the bidders. And the judge dismissed the petition and said, well, I'm dismissing a petition, so you don't need discovery. So we never got it either formally through that process, through FOIL, or informally through the promise that the city made when they opposed our application.
Thank you, Counsel. Thank you all.
Thank you, Your Honor.
Brunel Realty v. Planetarium Travels. Please.
May it please the court, Peter Kane from Belkin Burton Goldman LLP on behalf of the plaintiff appellant Brunel Realty, which I'll be called as owner. In this commercial plenary action, owner is seeking unpaid rent against tenants based on a default in the payment of rent. While the court below properly granted liability as to the owner, the court erred in failing to dismiss the constructive eviction counterclaim brought by the tenants. As your honors are well aware.
Was there an obligation on the landlord's part to make repairs?
Under
Article 4?
Absolutely. First of all, it's a covenant of good faith and fair dealing in general. Landlords always obligation to make repairs. And that is a different issue than a constructive eviction issue, which
with the ceiling collapse and the resulting mold, how is it possible that they can stay in the premises?
So Your Honor, first and foremost, there is no allegation that they vacated the premises. And as your honors are well aware, that is
There was no allegation that what?
That they vacated the premises.
They stayed there, you say?
No, Your Honor. On page 235 of the record, in fact, Ms. Rodriguez explicitly states they left, but I think we all know the reason why, and she states, the premises were vacated due to COVID. This is a travel agency. We all unfortunately know what happened to the travel agency industry in general, And they vacated, but as Ms. Rodriguez states herself, they vacated due to COVID. The mold report that Your Honor brings up, in fact, which is brought into the record unsubstantiated without an affidavit, but nonetheless, it never mentions black mold, and it references slightly elevated toxins from the mold, only 3 or 4 times. In no way does that mold report infer or imply that tenants had to vacate.
So you're saying that the recurring leaks took place after COVID?
Your Honor, I'm saying that the leaks initially occurred as the
Before, right?
they did occur before.
And they were from the roof.
They were from the roof, and as
And the landlord's responsibility was to take care of common elements such as the roof
absolutely, Your Honor,
and the exterior of the building.
Yes, and the record reflects, and even Mr. Fleetwood states that, in fact, there were many repairs done, and he actually thanked our client or a representative of our clients in 2020 for
Looking
finishing.
at the photographs that are part of the
Yes, Your Honor.
record, at what point in time were those photographs taken?
Well, there were certain photographs. Well, first and foremost, it's unclear.
The photographs show appalling conditions.
Yeah, again, Your Honor, there is no doubt that there were repairs necessary, certain repairs. There were no doubt, based on the record, that repairs were done. But what the record really fails to allege or establish, enough to defeat a summary judgment, is that they vacated the premises due to the issues at hand. The mold report does not imply that. The allegations in the record explicitly, there is no allegation at any time of a date that they vacated
So
due
you're saying there's an issue of fact?
No, Your Honor, not at all. The element and the dispositive element in constructive eviction is they vacated due to the issues in the premises. There is a clear and explicit statement they vacated due to COVID. When they tried to come back, they claimed to have mold. There is never an allegation that they had to vacate due to any repairs, any leaks, or any mold. And as I
So the duty to repair wasn't ameliorated by the pandemic.
Absolutely not. And in fact, as I stated before, we did do several repairs.
Which means that at the point where people would return perhaps to a premises such as this, there should have been no leaks, right? Because a landlord would have had all that time to fix the roof.
And again, we certainly did several repairs, and there's no indication from the record that we ever refused to do repairs.
If they left because of COVID, and when they want to come back, they can't come back because of a collapsed roof or because of mold, that wouldn't create an issue of fact about constructive eviction?
Your Honor, there's no indication that they could not come back due to the collapsed ceiling or the mold. The mold, as I said, the mold report, which was unsubstantiated without affidavit, never stated there was black mold or there was anything more than slightly elevated toxins, which in no way does that mean that you cannot come back into the premises. I see my time is up. If I don't have any more questions.
Any further questions? Thank you, counsel.
Thank you.
Ronald Hariri for the respondent tenant. I think the court has already recognized there were multiple issues of fact in this case. All the court did.
What's your response to your colleague's claim that there's no showing here of a constructive eviction?
You have the black and white, uncontroverted evidence of the photographs. You have the uncontroverted affidavits of Blake Fleetwood, the principal of the tenant, and Sally Rodriguez as to the horrendous ongoing conditions at these premises, including chronic leaks, mold, termites, a collapsed ceiling that rendered these premises unfit. And I think what you see with the lower court is he's saying, I've looked at the lease, there are a bunch of different provisions that come into effect. All of these provisions need to be construed against the draftsman, namely the landlord, namely paragraph 4 of the lease, the tenant may receive damages for breach of contract, paragraph 9, if the premises are not habitable,
the rent needs to be apportioned. Paragraph 8, the landlord responsible for damages, and a covenant for quiet enjoyment.
Counsel, speaking of, while we're on paragraph 9, doesn't paragraph 9 says that both sides have to look to their insurers first before they can sue the other side?
And all of these are questions of fact, and the judge below.
How is that a question of fact? It's like a very declarative sentence in the contract.
Right.
You got to look to your insurer. Did you guys get insurance? A, and B, did you put in an insurance claim?
Right. So that's addressed in the record.
Okay.
And
tell me what happened then.
And they were not able to get coverage. They were not made whole for this. So that's why the judge properly said.
Any question as to the cause of the mold, the ceiling collapse?
No, it's clearly the landlord's responsibility. Mr. Fleetwood is 80 years old. Okay, he wasn't causing the mold in his premises. I mean, this is all a landlord that completely ignored its responsibilities and is now trying to stick our client with rent. And I think what the judge below did, and you could see his thoughtful analysis saying, look, I don't think anybody should be in a place and not pay anything, but you need to have a hearing and you need to have each side put together their evidence and their proof. And that's what a judge should be doing here. There are factual questions. The context is not after trial. It's simply a motion for summary judgment.
Counsel, I'd like to go back to the insurance question very briefly. When you said that there was no coverage, you mean that no policy was issued, no policy was sought, or that a policy was issued and they said, no, we're not covering this?
They're not covering you.
So there was a policy, but they said no way?
Right. So again, I think
if I may, Counsel,
Sure.
the photographs were taken before or after the vacatur because of the pandemic? Before.
Right.
And do we have pictures after where the, I believe was the guarantor said, look at this, the damage from the roof had yet to be replaced?
Well, I mean, what they say, and there are also emails attached, is that this has been a chronic problem, in which many, often roof leaks in an older building will be a chronic problem. Maybe there was some efforts, but our clients say that this has been a continuing, ongoing problem, and the landlord hasn't addressed it, and that's the question of fact. All of this, how long did the conditions exist? What did the landlord do or not do? What amounts might be due? What abatement is appropriate? All of that, the Judge aptly said, is, guys, you've got to go to trial and prove your case. There'll be questions of credibility. There'll be questions about evidence. As far as the hearsay claim about the mold report, remember, the issue on summary judgment is not issue determination, as you've all aptly said in many of your opinions. It's issue spotting. And there are a heck of a lot of important issues here that deserve to be addressed at trial. If you have any questions.
Thank you, Counsel.
Thank you.
I think I gave you 1 minute on rebuttal, too, so you can respond at that time.
Thank you. Very quickly, this is the constructive eviction counterclaim is very specific. It's not about abatements. It's not about repairs. It's about whether or not they vacated the premises. And I once again, cite to the record for Ms. Rodriguez at 235, where she explicitly states the premises were vacated due to COVID. Further, I want to highlight that the arrears commenced not
constructive eviction if you can't return when you want to.
Yes, so again, they never said they couldn't return. They said they, in fact, did not vacate until a month after the lease term expired in September.
I understand your colleague is saying that it's apparent from the photos that they couldn't return.
Yeah, again, there is no allegation they couldn't return. Those photos were in the basement. This is a travel agency on the top floor in the retail premises. Certain black and white photos which do not indicate that they could not return. Further, the date of the arrears I want to highlight commenced.
The photographs were of the basement?
That is of the basement, is my understanding. Yes, Your Honor. Again, the arrears issue.
More like an office.
There's an office on the top, and then in the basement. That's where I saw most of the. That's where my understanding of the pictures were. Again, the arrears commenced. They stopped paying rent on 4/1 2020, which again is not surprising. 4/1, that's COVID. They stopped paying on 4/1, not because of the rent, not because of the repairs, not because of the ceiling, but because their industry was destroyed. And unfortunately, that's the case. And your honors have held many times the frustration of purpose is not a cause to stop paying rent. Lastly, I would remind you, Your Honor, opposing counsel brought up quiet enjoyment. That quiet enjoyment cannot be pled if you're in default. They were in default of 4/20. They stopped paying rent as of 4/20, 2020. They cannot maintain a claim for cause of constructive eviction for the reasons stated, and also for quiet enjoyment because they were in fact in default on their payment of arrears. Thank you, Your Honors.
So here's what the able trial judge or motion judge said. I'll keep this counterclaim for constructive eviction because I think it also encompasses, again, I think it encompasses the failure to make repairs, whether the failure, if it's proven, rendered the premises not fit for purposes. There are all kinds of questions of fact about the water leak, whether it was caused, when it was cured, the damages, and all of this evidence is properly before the court at the trial level. It's not ripe for summary judgment. The court below was correct in saying maybe you need to pay something, but that's for a hearing at a later date where all parties have a chance to submit their evidence. Thank you.
Thank you, counsel. Thank you both.
Thank you, Your Honor.
Goldman v. Icaro Media. Please.
Good afternoon, Your Honors. Brian Hoffman from Prior Cashman, along with my colleague Todd Soloway on behalf of petitioner appellant Lloyd Goldman. My client invested approximately $2.6 million in respondent Icaro Media Group, the CEO for which is respondent Paul Feller. Upon learning that Mr. Feller had been adjudicated by a California court liable—
Put the microphone a little closer if you would.
Sure.
Maybe I'm hard of hearing today. That's fine.
Liable for approximately $20 million in damages related to breach of fiduciary duty, fraud, among other things. In connection with Icaro, my client requested records, information related to his investment in Icaro.
It seems like this common law right that you're asserting doesn't have much precedent behind it, except kind of wiggly precedent. But wouldn't it drive a truck through, because this is a foreign corporation, doesn't it drive a truck through the provision that covers? I mean, that's the issue in this case. Covers the access to internal documents of foreign corporations.
It doesn't drive a truck through it, Your Honor, because Section A of BCL 1315 outlines—
No, but aren't I talking about BCL 1315? That's the one from foreign corporations.
Correct. If I misspoke, I apologize. BCL 1315A is the portion of the statute that outlines that you have certain records that are a shareholder's entitled to. For example, names, address, the amount of shares, when they obtained it. But BCL 1315D expressly preserves the common law right of inspection for a shareholder in a foreign corporation. So how do those two exist together? They exist together because BCL 1315D was expressly preserved for just this type of circumstance, for a circumstance where a shareholder is entitled to more than just those documents outlined in BCL 1315A. The Poikyoy case, the Pomerantz case cited in our briefs, they expressly say that the common law right is broader than the statutory right. And the case law we cite says as well that the common law right exists. And BCL 1315, if you think about it, Section D of it, the legislature was intentionally vague about what a shareholder is entitled to. They outline what a shareholder is entitled to in Section A, but not in Section D, because they recognize that courts need the discretion to be able to award a shareholder the types of documents that they are entitled to under the given circumstances. And I would point the court
Counsel,
to—
what about the internal affairs doctrine? How does that flavor what you're arguing before us.
The internal affairs doctrine, Your Honor, has absolutely no
It
application.
has nothing to do with
Has
anything?
nothing to do with it.
So New York laws govern with respect to disclosure, and it's not the substantive law of the state or the country of incorporation?
Correct. And I would point the court to the Colbert case, which is cited in our brief, which expressly says that in the circumstance of a request for books and records, the internal affairs doctrine does not apply, that it is New York state law that applies. And I would add to that that the Eccles case, which is a recent case, that talked, not a books and records case, talks generally about the internal affairs doctrine and how it applies in New York. It says that the presumption is that the internal affairs doctrine applies to substantive matters of a corporation. This is not the substantive matters of a corporation. This is not, for example, breaches of fiduciary duties of directors and officers.
Books and records aren't substantive?
Correct. They're not substantive. This is simply a request for books and records so that my client can understand and analyze what has been done with the $2.6 million that he invested in Icaro.
Another question from Justin.
If we were to affirm, could you go to Nevada and ask a court there for the documents that you're seeking?
Could we? I mean, the extent of the documents that we seek here, I'm not sure. There is a more limited set of documents under the Nevada statute, but again, the Nevada statute is inapplicable because the internal affairs doctrine does not apply, and New York is the place for us to do it. And let me just say one last thing. Mr. Goldman is a New York shareholder. Icaro is a New York, although they are incorporated in Nevada, principal place of business is here in New York. They have done more than take advantage of New York in doing business. And there's no need to go to Nevada because in this type of circumstance, BCL 1315 expressly preserves our ability to seek and obtain these documents here.
You have time in rebuttal.
Thank you.
May it please the court, David Berman for Icaro Media Group and Paul Feller. Essentially, the court has sort of zeroed in on the positions in my brief that basically our adversaries are forum shopping. Our adversaries are demanding documents far outside the scope of the New York statutory scheme. If they had filed this case in Nevada, they would not be able to even ask for these sort of documents. And I also want to point out that a number of the cases that our adversary is relying on predate the existence of the BCL. They predate the existence of both statutes. And then on top of it, I'd also like to point out the, pardon me, the Hokyuk case, which they rely on for the common right of inspection being broader than the statutory right. This case is entirely limited to BCL 624, which is the domestic case. It seems to me that their call...
Why do you say that it's limited to domestic corporations?
Oh, BCL 624 is a statute for domestic corporations, Your Honor. That's the reason I say it. 1315 through the statutory scheme is a statute that is explicitly there to apply to foreign corporations.
So in your view, the internal affairs doctrine very much applies?
Correct. And that Justice Getz was correct in his citation to it and to Eccles. There's a presumption in Eccles that the adversary who's trying to overcome the internal affairs doctrine and have the internal affairs of a company be governed by foreign law in New York, they have to overcome a strong presumption that the law of the jurisdiction in which the corporation is incorporated should apply.
Your colleague says that the principal place of business is in New York.
That is correct, Your Honor.
Isn't that, does that trump the interests of New York?
I don't believe...
Does Nevada's interest overcome the interests of New York?
Well, I believe it does. I believe it does in the sense that our adversary is seeking a wider a much wider scope of documents than he would have available in Nevada if he used the Nevada law. And merely because the corporation has its principal place of business in New York, I don't think that that justifies this type of forum shopping. Additionally, the canons of construction, as Chief Judge has pointed out, would really militate in favor of Justice Getz's reasoning, because otherwise, as the court has so wisely pointed out, a truck could be driven through the statutory scheme if this common law right broke open the right of foreign investors to demand vast amounts of documents from New York corporations at a whim. I think with that, I rest.
Thank you, Counsel.
Your Honors, I have a few things to say. The IAS court's decision was error for several reasons. It completely didn't reference BCL 1315D. No word of it. And let me read that out loud. Nothing herein contained shall impair the power of courts to compel the production for examination of the books of a foreign corporation. That's the language of the statute. It's expressly on point. The IAS court didn't mention it, didn't address it, didn't analyze it. With respect to the cases the IAS court cited, I want to specifically address Crane, which is a Court of Appeals case. That case expressed...
Also address Eccles, which is a 2024 Court of Appeals.
Sure, Your Honor. I addressed that before. That case is not a books and records case. It has nothing to do with the common law right of inspection. Crane is a case that is on point, and it says that where a shareholder has a good faith and proper purpose, a common law right of inspection is permissible. With respect to the Sadler case that my adversary mentioned, it's a Second Circuit case. That case said absolutely nothing about the common law right of inspection. It is a case that has to do with the applicability or the ability of a shareholder to seek BCL 1315 under the Internal Affairs Doctrine and the Commerce Clause of the United States Constitution. The Second Circuit said it was permissible. I also want to make one final point.
In conclusion, how do you reconcile or harmonize Section 624 and 1315?
I mean, BCL 624F says the exact same thing as BCL 1315D. They are just for different, one is for domestic corporations and one is for foreign corporations. There's no, and in fact, the legislature provided two separate provisions for the very reason that foreign corporations should be able to obtain the records under the common law. If there was going to be, only one statute, there would have been only one statute.
Doesn't mean you're entitled to something less than you would be entitled to under 624?
I didn't hear you, I'm sorry.
And 1315 doesn't mean that you're entitled to something less than you would be entitled to under 624?
No, Your Honor. The language is exactly the same, and I would also point the court, I see my time's up, but I just want to point the court to two cases. The Stupak case, which says that complete books and records a shareholder in a foreign corporation is entitled to. And I also want to point the court to the Rogers case, which outlines a very long list of documents that the shareholder in that case, both of these cases are foreign corporations, a very elaborate set of documents that the shareholder is entitled to in that case.
Thank you, counsel. Thank you both. Finally, People v. Darbasi.
Good afternoon, Your Honors.
Wait for your opponent to get up, counsel. Thank you. Okay, thank you.
Good afternoon, Your Honors. My name is Albert Ebanks, and I represent the appellant in this case, Steve Darbasi. This case asks this court to consider the question of whether a defendant may be convicted of felony witness tampering and intimidation in a case where there is not a threat, in a case where...
It wasn't threatening to create a new Instagram account and to allow people to post to it that did say fairly violent things?
Let me speak to that, Your Honor. The page that's created is the Rat's Instagram page. That page does not, in and of itself, contain a threat. The statute is very clear. for both 215.15 and 215.11, tampering and intimidating a witness. There's a specific requirement, an element that must be met. And that requirement, Your Honor, is that the actor must instill fear of physical injury.
Counsel, there were photographs of the interviews between the witnesses who eventually decided not to testify, and the people and police and so on and so forth. That very private sanctum, so to speak, all of a sudden was posted on the web. Isn't that absolutely terrifying?
No, Your Honor, it's not.
You're disclosing what you saw, you're disclosing what you heard.
What was posted was offensive. I'm not here to support what was posted. It was offensive conduct. Maybe it was a mean page.
Snitches, rats, there were little rats on the pages.
The word snitches is not really part of this post. What really is part of this post, Your Honor, is you have a father who's frustrated by what he perceives to be the failure of the judicial system with regard to his son.
Doesn't that father then go say to the world in general, and perhaps to the people who look at his website, not what, you know what I'm talking about.
Post.
Go get him. Doesn't he essentially say, go get him, or?
He does not, Your
Are
Honor.
you surprised?
He does
when
not
the
say.
windows were broken from the car.
The one thing that he does say is spread the love. This is what he says, spread the love. He wants this cause to go viral. He wants to draw attention to the fact that the witnesses who you see on the page are gang members who are being embraced by the New York County District Attorney's Office as witnesses in a case where his son was forced to defend himself. He is not in any way soliciting any kind of violence. And it's certainly not something that would fall in line with Section 20 of the penal law, which lays out accessorial liability. Just posting an angry page in and of itself is insufficient.
Was it one page? I thought it was many, many posts.
It's a page where there are several posts, but none of these posts have any kind of threat. There's never a threat that is made. That's one thing that I can tell you. When I sit down, Your Honor, I hope that my adversary can point out one threat that my client makes. He will not. He cannot, because he will not. There's not a threat that's made. It's an angry page. It's a mean page. It's an offensive page. It does not rise to the level of the felony crimes with which he is charged.
But the responses, weren't there very threatening responses from people who saw that?
Your Honor, thank you for your question. Some of these responses come 15 to 20 days after the statutory period or after the period charged in the indictment. He has no control over those statements that are made on his page. Really, he is responsible for the content that he creates, not for the statements that people make on his page. He can't possibly be asked to police the comments and the mental states of other people unless there's some accessorial liability, which there is not here. He never speaks to these witnesses. He never sends them a message. There is no direct contact. In fact, this case has everything.
Isn't it a message
except
when
evidence.
you put people's pictures on a account that's it's called Rats 13? Isn't that that's a statement?
That is a statement. That is not a felony crime. Rats 13 is offensive, Your Honor. These statutes are very clear. You must instill a fear of physical injury.
Okay, and we're allowed to consider context, correct? In other words, it's not just what's on the page, it's also what's in the community, correct?
Your Honor, I'm reading the statute. The statute says that you must instill.
And how do we instill fear? Can one instill fear in the community by using certain coded words to say these people are bad?
The coded words would maybe make out the misdemeanor. By the way, all of the people's cases make out the misdemeanor where there is not a requirement of a threat. These sections also progressively increase. If there's a threat, that's the felony. If there's not a threat, that's the misdemeanor. Perhaps they should have charged a misdemeanor. I'm certainly not here to concede that he's guilty
We'll
of
have
that.
time on rebuttal, counsel. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Hunter Barron for the people.
Am I mistaken, or counsel, did the defendant leave up comments to the post that threatened the witnesses?
You did. That were explicitly
You can
threatened.
take those down, right?
Yes, absolutely. And I would argue, Your Honors, that this entire page was a threat. The jury could infer that it was a threat. There's no requirement in the statute that the defendant has to say something directly to a witness to the effect of, if you testify, I'm going to hurt your family or break your legs or something to that effect. The jury could look at the totality of the circumstances of what was happening here and conclude reasonably that this defendant was seeking to instill fear that he or someone on his behalf.
Did Almeida or Benitez or Ms. Bonet testify at defendant's trial?
No, they did not. There were investigators that tried to contact them and get them to testify, and in fact, Bonet said that she feared for her physical safety and did not want to testify.
Did they move as well?
I'm sorry?
Did they move also, Almeida and Bonet?
I believe they did move. I'm not totally positive on that, Your Honor. So unless Your Honors have further questions about any of the evidentiary issues or the jury note issue? Okay. Thank you.
Thank you.
Your Honors, let me speak to the jury note. In this case, the jury asked a very specific question. It's a question of attribution. They said, can we infer that the statements made on this post are the same as Steve, meaning Steve Darbese, the defendant? The answer to that question had to be a very simple no. What the judge did here was basically invite the jury to create a new theory of accessorial liability where none of the requirements had been met. There was no
Well, if the
communication.
judge answered no, wouldn't he have been making a factual finding?
It's not, the question was a question of law. May we assume that these statements are the same as the defendant?
Well, isn't there a factual question as to where these statements are coming from?
No, it's a question of law, Your Honor. In my opinion, this is a question of law.
Is there an objection?
There was a strenuous objection, Your Honor. There were objections all throughout. At some point, I started to think of this case as the Madison Avenue Express. The rulings all
I
throughout.
don't know what a Madison Avenue Express is. I know what a slow bus is, but express?
You're looking at it here, Your Honor. The Crawford issue, the posting a video of a murder on a case where there's no violence alleged, the suggestion that offensive speech is equal to a felony conviction. If that were the case, Your Honor, we would have empty apartment houses. You can't consider the term rats to be something that substitutes for what the legislature deemed necessary to meet the felony elements required in this statute. I see that my time is up unless the court has any further questions.
Doesn't look like it, counsel. Thank you both.
Thank you.
Be well.